Time for the toughest part of the seminar. Absolutely the toughest part of what we're going to do. This is over half the slides. It's actually more like, it's most of the slides. We're going to talk about pay or play. Some of you have heard me talk about pay or play before. And most of the presentations I've done for Connell, this has been part of our topic. You may have heard me somewhere else. As you're probably aware, we received some new rules in February, which were called the final rules. The rules I spoke on last time were the proposed rules. And it was really interesting when these rules came out because I saw a lot of articles which said, rules finalized, not many changes. I thought, well, which ones did you read? Because the rules I read had a lot of changes. Now, they weren't necessarily changes that kind of reversed something. We previously meant A, now we mean not A. But they were rules which tweaked what we had before, or which provided some further definition on what we had before. And in a lot of cases, thanks a lot. A lot of cases they added to, and then in many cases they delayed. And then they looked at different groups and thought how the different rules are going to apply to different groups, particularly what they call smaller employers. And now that's one of my favorite uses of the word. You have small employers, and you have now with the new regs, and we did before, large employers, but with the new regs you now have smaller employers. Now, before you look at anything, where would a smaller fit? Would they be less than a small or more than a small? What do you think? Less, right? You got small and then you got even smaller, right? No. Smaller is bigger than small. Yeah. And I read that and then went and did like an analysis on my coffee, thinking maybe there was something in it I didn't realize. But you've got small employers, and then you've got smaller employers, and then large employers. So I'm not going to use that terminology today. I'm going to call them small, mid-size, and large. Because to me, smaller should be smaller than small. Anyway, I'm not sure what dictionary they used. A big part of what's in these rules are delays. And they're delays for selected groups. And one of my associates and I, her name is Laura Bibb, we're going through these and we're revising our slides, and we're both hitting, April and May just tend to be very heavy teaching schedules. We're both doing a lot of teaching, and we were going through these rules, and then even in the car yesterday, when I got here, I thought of something, and when I got here, I said, I think this is what's really going on. As you probably know about me now, I like to dig down to what is the real kernel in this thing. I mean, what's really going on? How can I summarize this as easily as possible? And I think this is what's really going on in the final rules. The White House and regulators are saying, we're going to provide you some relief, but you have to play fair too. Okay, got that? We're going to provide you some relief, but you have to play fair too, meaning don't try to pick this apart and find loopholes and do something that's against what we're trying to accomplish. So keep that as your mantra as we go through these rules. Now, I know a number of you have heard me go through these pay or play rules before. I will be going through them in a very similar order to what I've done before, but as we go through them, I'll be pointing out what's new. The other thing I will say is, as Tom mentioned, we have written an article which you have delivered to many of your clients, and more later, I understand. And that article will kind of be a prose format for what I'm talking about today. So just in case, I know this is a very remote likelihood, just in case there's something I go over that you don't understand today, you might try that article. I mean, I can't think of a better thing to do than go read that article over the weekend. Who wouldn't want to do that? But let's get back to that kernel. And so I sent this to Laura last night, and she replied a little bit later, said, yeah, I think that's basically what it is doing. We're going to provide you some relief. We understand these rules are difficult and onerous. We're going to provide you some relief, but you have to play fair too. And I'll show you what I mean as we get into all this. The rules were initially delayed until 2015. The guidance came out July of last year. The IRS encouraged all employers to go ahead and expand coverage even with the delay. The delay also delayed the required information reporting, which I'll talk about at the very end of this. The final regulations were issued February 10, 2014. Probably the second most important date in the ACA, second only to March 23rd, 2010, the day the ACA was signed into law. These regs were issued February 10 of 2014, and you're going to see that date a lot in these next 50 pages of slides. As we go through this, when I was here last time, I don't remember when that was, several months back, I said this is a 4-question analysis. Now it's a 5-question analysis. Once again, we try to take these rules and put them into bite-sized chunks. You're not going to find these 5 questions in the regs. This is how we're saying, take these regs and organize them like this so that they make sense. Number 1, are you a large employer? Because large employers are subject to the penalties. Number 2, this is the new one. What is your compliance date? And there are going to be very differing compliance dates for differing employers. So that's our new question. Number 3, who are your full-time employees? Number 4, what are the penalties? And number 5, what are your options with respect to the penalties? So we're going to go through these 5 questions. This is going to absolutely be the toughest part of the morning. These rules are extremely difficult and complex. Number 1, large employer status. Are you subject to the pay or play penalties? Large employer status means 50 full-time employees, taking into account FTEs, which are full-time equivalents. Okay? Some of this you've already heard and know, but we're going to go over it again just to get the playing field leveled. If you have less than 50 full-time employees, there's no penalty. If an employer has a health plan or doesn't have a health plan, but has fewer than 50 employees, including full-time equivalents, don't worry about it. No penalty. 50 is a very key number. One of the things that we'll talk about is, if you've got more than 50, can you take a class of employees and exclude them? And the ability to do that is going to come under 2 sets of rules. The pay or play rules, but what other set of rules that I mentioned earlier? Non-discrimination rules. Is that class a class of non-highly compensated employees? If so, then the 105H rules, or rules similar to 105H, will kick in at that point. So you have to worry about a couple of sets of rules. To determine your large employer status, there is a look-back determination. For 2015, since these penalties have been delayed to 2015, you can use any consecutive 6-month period in 2014. Once we're at the 2016 rule, looking at 2015, you'll have to use a 12-month period, or the calendar year. Now, I just said this is a 2015 rule. It's the same rule we had for 2014 before the delay. The only change was the years, that we're using the 14 numbers to determine the applicability in 15. An employee who works 30 hours per week or more is a full-time employee and counted for everyone else. We look to whether they are full-time equivalents, meaning they work 120 hours per month, or you find 120 hours per month by combining together, and you come up with one full-time employee. So if you have two half-time employees essentially become one full-time employee. Okay? You know, that's true beyond benefits, right? You've got some employees that are like half an employee, but they may work 40 hours. New items in this determination. A lot of groups have written since the proposed regs were issued saying, how does this apply to my industry? We've got some weird types of employees. And so we have several rules addressing that. I had a couple questions during breaks with educational employers, K through 12. I do a lot of work with K through 12s and college groups. They have some questions directly addressed. First are bona fide volunteers, like a volunteer firefighter. They're not included even if they're reimbursed expenses or some nominal pay, but they're a volunteer firefighter. Obviously, a fully employed firefighter would be an employee. I work with a lot of colleges. One of our questions was relating to work-study students, and that's been answered, that they are not employees, they're students. Interns, if they're paid, they're an employee. If they're not paid, they're not. Monks and nuns are not employees if they are subject to a vow of poverty. Employees with unique hours, there are special rules on these. All these are new. Again, with my college groups, adjunct faculty, huge issue for colleges. A lot of colleges are using more and more adjunct faculty, and the stats for many colleges, half the professors are adjuncts. And adjuncts typically aren't entitled to benefits. And they've only calculated their hours based on the hours teaching, and the rules say you have to also calculate hours in preparation. Other unique situations are on-call employees, like in hospitals, airline employees, who kind of like firefighters work really long days but then have long breaks, employees with layover hours, and commissioned sales folks. Lots of unique rules on these. I'm not going to go into all of them. But these employees are excludable from the calculation. I've got them listed in 2 slides. And now we're talking with respect to the concept of, are you a large employer? These same slides are going to come up later in terms of who do you have to pay a penalty on. So we're going to see these 2 slides again at a later point. All right, let's look at how we're going to make that determination. I'm going to go through this pretty quickly because a lot of you have already been through this with me. To determine if you're a large employer, first off, determine the monthly average of full-time employees for the preceding year. A full-time employee is an employee who works 30 hours per week or 130 hours per month. Why 130? Because there are 4.2 weeks in a month. And so they upped it from 120 to 130. For non-hourly employees, you'll use some sort of equivalency. For adjunct faculty, that equivalency is the 2.25. For every hour of teaching, they actually work 2.25. So you take the total number of full-time employees and you divide it by 12, or 6 if you're using a 6-month measurement period, and you take the total number and divide it by 12. Step 2 is then you look at the number of full-time equivalents, or FTEs. I've always done full-time employees as FTEs, and now we're doing, and I've actually come up with new abbreviations, which I'm going to use in the next set of slides. Full-time employees, I now say FTEE, and full-time equivalents, FTEQ. And that's actually a lot easier than writing out equivalents a bunch. So look at the number of equivalents, and this applies to employers working less than 30 hours a week or 130 per month. So if they're working less than 130 a month, you look at the total hours worked and divide it by 120. And then divide that by 12 or 6, depending upon the measurement period. You notice something weird in that number? You see a typo there? 120 instead of 130, right? Yeah, it's not my typo, that's Congress's typo. Even though it's based on 130, you divide by 120. I've been asked many times why. I said, you know what? Sometimes Congress makes a mistake. There's no reason why. Step 3, determine the monthly average. You add step 1 and step 2. The number of full-time employees plus the number of full-time equivalents. And fractions are disregarded. So if you add step 1 and step 2, and your answer is 49.9, in elementary math, that would round up to 50. Under the ACA, it's 49. Everything rounds down. So 50 really means 50. It does not mean 49.5, and that's good for us. So I'm not complaining, I'm just telling you. If step 3 is less than 50, stop. Not a large employer, not subject to the penalty. If it's 50 or more, the employer is a large employer and subject to the pay or play penalties, and you need to move on to our second question. As you look at that, there are a couple of issues which are now going to come into play, and we'll talk about those. First off is the mid-size employer delay, and secondly is the seasonal worker exception. I want to point out, just like the 120 and the 130, there are 2 different definitions of seasonal worker in the pay or play rules. One uses a 4-month calculation and the other uses a 6-month calculation. And I will be explaining that to you here in just a little bit. Second question, what is your compliance date? We added this as the second part of the test because there are so many aspects of relief in these regs that it becomes its own issue. The first delay is the smaller employer delay, which I call the mid-size employer delay, okay? There are no penalties for the 2015 plan year if step 4 results in 50 to 99 full-time employees. So a mid-size employer, also known as a smaller employer, is an employer with 50 or more full-time employees and full-time equivalents in 2014. For those folks you first look at, and this is a key part of this date, has the workforce and the overall hours been reduced between February 9th and December 31 of 14? Remember I told you you would see that February 9th date again? It's very key. I said the 2 basics here are, we'll give you some relief, but you have to play fair also. What this is saying is you can't read our rules, which we publish in February, run the test under the new rules, and then fire people to get down to a lower number. It's based on the number in play at the date of our publication of the final rules. So that's why February 9th is in there. You with me? Okay? Unless it's for a business reason unrelated to the relief, such as a sale. Laura and I were talking through this last night, and we said, it's got to be a legitimate sale. It can't be, I sold my business to a trust for the benefit of my son, and I'm the trustee of the trust. That wouldn't be a legitimate business reason, okay? Second part of this is that the health coverage offered as of 2/9/14 has not been materially reduced or eliminated. Again, they're saying we'll give you relief, but you can't screw the employees after February. Okay? You got to stay with the rules that are in place. Next, an employer, this is the no coverage penalty relief. An employer will not be subject to the no coverage penalty, the $2,000 penalty, for each month in 2015 and any months in the 2015 plan year that fall into 2016. So if it's an October 1, 2015 plan year that goes to September 30, 2016, those first 9 months in 16 would get the same relief if the coverage is offered to 70% of the full-time employees and dependent children. Okay? So, for 2016, the rule that was already in the regs, the 95% rule kicks in. For 15, the rule is now 70%, and if you're really trying to think, how am I going to remember this? Circle the 70 and the 95. That's the difference. For 2015, you have to cover 70%. For 2016, you have to cover 95%. 95% was already in the regs. The relief said for 1 year, we're not going to enforce 95, we're going to enforce 70. Okay? Now, let me just talk a little bit from a policy standpoint. There's tons of political discussion about how many times the White House administration has delayed enforcement of certain rules. All I want to say is every president does this, and the opposing party gripes every time. It is nothing new to provide relief from onerous regs, happens all the time. So this is relief saying, we're not going to enforce the 95% rule next year, we're only going to enforce the 70% rule. However, and you might want to write this at the bottom of the page, this is only applicable to the no coverage penalty, the subsection A penalty, or the $2,000 penalty, however you want to call it. This is not relief from the unaffordable coverage penalty. So even though the no coverage penalty might not apply, the unaffordable coverage penalty still does apply. I told you this was going to be a difficult part of the chat. You should really see the look on your eyes right now. You liked me more about 45 minutes ago than you do at this moment, but okay. This is only the no coverage penalty. The unaffordable coverage penalty might still apply. Okay, those were the easy ones. Now let's get to the complex ones. Non-calendar year relief. There are 3 relief options. If eligible, the compliance date is first day of 2015 plan year. There are 3 general requirements for all of these 3 transition reliefs. Applies to a non-calendar year plan as of 12/27/12. You can't change from a calendar year to a non-calendar year now and get this relief. You had already made this change by 2012. That's first. Number 2, you've not modified the plan after that date to begin at a later calendar date. And 3, you must offer coverage to at least 70% of the full-time employees. These 3 general requirements will apply to all the relief I'm going to talk about in the next few slides. First off is the pre-2015 eligibility transition relief. This means there will be no penalties prior to the first day of 2015 plan year for any employee when hired who is eligible for coverage on the first day of the 2015 plan year on the terms and effect of what date? You've got it memorized now. February 9th, 2014, when the rules were published. They offered affordable minimum value coverage as of the first date of the 2015 plan year, and they're not eligible for coverage under a cafeteria plan of the employer as of 2/9/14. I put here carve-out plans beware. This rule is going to shut down a lot of carve-out strategies that have been going on in the market, trying to carve out certain groups of coverage because the carve-outs take place after the regs were brought into effect, and we've got all these dates that we keep going over and over again. Relief number 2 is the significant percentage transition relief. This provides relief if the employer covers at least 1/4 of all employees. All means full-time and part-time. 1/4 of all employees on any date between 2/10/13 and 2/9/14. There it is again. All over the place. They offered coverage to 1/3 or more of all employees during the open enrollment period ending before 2/9/14. There are no penalties for any full-time employee offered affordable minimum value coverage or not eligible for coverage under a calendar year plan of the employer as of 2/9/14. This rule will impact employers that have a large part-time population, like restaurants. You know, we see a lot of restaurants out there. We might have 50 employees. 6 of those are managers or assistant managers who are on a plan. 44 do not have coverage. That employer would not meet this relief because they're not offering coverage to more than, or to at least 1/4 or 1/3 of the workforce. You with me? In that case, they're offering it to 6 out of 50. And that will not entitle that employer to this relief. This could also affect other types of carve-out plans. And it could also affect what we're calling skinny plans, and I'm going to talk about those later. The third relief is a significant percentage transition leave for all full-time employees. The percentages for all employees was either 1/4 or 1/3. This test works exactly the same, except the test is just applied to the full-time employees. And instead of 1/4 and 1/3, the percentages are 1/3 and 1/2. Okay? Oh man, you are digging this. I mean, whew. Okay? That's our third type of relief. So you look at 1/4 and 1/3 for the entire population of employees, or 1/3 and 1/4 for the others. The fast food example I gave you would meet this test, because you got 6 full-time employees and all 6 are offered coverage under the plan, so the only full-time employees are getting coverage at 100%. But it would only apply for 1 year because it's just a 1-year relief, and the affordability argument would still be there too. So you would still have potential under other penalties, but there is a possibility for some planning here. All right. I realize that was really difficult. Let me just say one thing. I am not going to be able to answer all your questions about your specific situations today. In terms of whether these will work or not, you'll need to work with Connell or somebody else or us if it's really tricky on how do these rules actually affect you. So that's the relief. Now we're going to look at, you're just standing.
I was just going to open it up for questions on those 3, not necessarily in the specific, but more on a general basis.
Okay.
If anybody had any. So I know that's pretty intense.
I think they're too foggy.
It's pretty intense, and it's a lot of information.
Now, full disclaimer, did I not tell you to get coffee before this section? Okay. All right. We'll come back to questions at the end of the whole pair play. All right. Who are your full-time employees? This is roughly the same. We'll have a few changes, but not as much as on that second section. The penalties are only triggered by full-time employees, so who's a full-time employee? The test for full-time employees is different in phase question 1 than it is in question 3. Question 1 relates to, are you a large employer? And then you'll look at full-time employees and full-time equivalents. Now we're looking at the are you a large employer relates to, are you subject to pay or play? Now we're looking at who's a full-time employee, because the penalty only applies to full-time employees. Okay? So the determination is going to be a little different than it was under the definition of a large employer. Full-time employee, this part's the same, 30 hours a week. We also have a definition of a variable hour employee, where the employer can't determine whether the employee is expected to be full-time at the start date. We have a definition of a part-time employee, which is basically an employee that's not a full-time employee, which, duh, but we didn't have that before, so it's good to have it. And then we have a seasonal employee. Remembering back to the first test, a seasonal employee was an employee who works 4 months or less. For the third test, it's 6 months instead of 4 months. And now, this rule is really going to be important for you all in Branson. Okay? You've got lots of seasonal employees if you're in entertainment or hospitality down there or related industries. So this is something that's going to be of big effect to you. So the part-time definition, the seasonal employee definition are new. Remember this for seasonal employees, all you Bransonites. Defined by 4 months for the determination of large employer, 6 months for determination of full-time employee. Identifying the employees, there are 2 ways to measure. And I really don't like this next rule, but it's a monthly measurement rule. You know, under the other rules, you measure this once a year. This is for those employers who are so masochistic that they want to run this test every month. But with some employee populations, that's actually the best way to go, because they might be an employer where that calculation can change very rapidly. So we have our regular look-back measurement, which we already had in the proposed regs, and in the final regs we have this new monthly measurement. And so the monthly measurement is you determine full-time status by calculating the hours during the calendar month. Or if you're really into this, you can even do it weekly. The employer can vary the category based upon that, but cannot base measurement on work schedules in terms of variable versus more predictable. The monthly measurement is measure as you go when you reach full-time employee status. When an employee reaches that status, you have to offer them coverage by the first day of the 4th month. First day of the 4th month, which kind of ties into our 90-day rule. Why would you use one over the other? My view would be, for most of you in the room, use the look-back measurement because it's more stable. You're doing it once a year. It's more stable, it's more predictable. If you're not sure, then you should try the monthly method for making this determination. All right. A full-time employee is an employee that's hired as a full-time employee, same 30 hours and 30 a week, 130 a month. The final regs have an actual definition of what's reasonably expected. What they're trying to avoid is an employer saying, going to hire you as a part-time employee, but you start by working 36 hours, and every week you work at least 36 hours, and they say, oh, well, we didn't really mean it. We still think you're supposed to be part-time. So it's like, what is the real expectation? It looks at things like, what did the listing for the employee position say? Did it say part-time or full-time? It's like, how many hours did the guy you replaced work? If that guy worked 40 hours a week, then we should reasonably expect that you're going to be working that and you're not actually a part-time employee. So those are the kinds of things that the regs look at and some of the things you have to look at. There will be no penalty for the first 3 full calendar months of employment if the affordable minimum value coverage is offered no later than the first day of the 4th calendar month, just what I said on the previous slide. What about other types of employees, such as variable hour, part-time, and seasonal employees, employed for 1 full measurement period? This ties back to the prior rule. The measurement period must be any 3 to 12-month look-back period. Can be a calendar year. If the employee averages 30 hours per week, they're a full-time employee. That's the same stuff. What's an hour of service? It's each hour for which an employee is paid, and that includes vacation pay, holiday pay, sick days, jury duty, military duty, paid leaves of absence. For non-hourly employees, for hourly employees, you calculate the actual hours. For non-hourly employees, you look either at the actual hours or an equivalency. And there are all sorts of equivalencies that are in these regs. What about excluded employees? These are the exact same two slides we had under the first test. So I'm not going to go over them again. But we've got our firefighters again, we got our interns again, and we got the monks, and we got adjunct faculty. And these are folks with unique hours. Now, I know there are school districts in the room. We were involved in the process of getting rules on adjunct faculty. We were also involved in getting rules on substitute teachers. We didn't do as well there. We don't have rules on substitute teachers yet. We've been working with a lot of school districts to come up with something reasonable under the prior rule, and we're basically having to stay with that because we have no further guidance on substitute teachers. We were also involved in wanting to get more clarification, which we haven't received yet, on coaches. Coaches work a lot more hours than they're actually paid for, okay, at both the high school and college level. So there's still a lot of unique hour employees for which they have not yet issued guidance. So if you're K through 12 or college, university, you actually need to pay real attention to that. I know we have K through 12s in the room. I don't know if we have college groups in the room. If we do, we actually have a memo that I can send your way on how these rules affect colleges and universities. Okay, ongoing employees. We looked at the measurement period, now we have the stability period. Basically the same as it was before. I don't really like the term stability period. I like to call it the coverage period, because that's really what it is. If during the measurement period you're a full-time employee, then you're entitled to coverage during the stability period, which I just say you're entitled to coverage during the coverage period. I just think it makes more sense than stability. So you have the look back, the measurement period, then you have the stability period, which must be at least 6 months long or if greater the length of the measurement period. You can also have a third kind of period called the administrative period. This is the period between the measurement and the stability period where you look at the results of the measurement period and say, we need to add these certain employees because of their number of hours, and therefore you then use the administrative period to pick up those people that you weren't covering and you bring them in. What's another word for an administrative period? Open enrollment, right, somebody got it. Okay, now, you don't have to have an administrative period. Most of my clients don't, because they just fold that into the other periods. They're doing their measurement and they don't want to have these odd time frames, and I'll show you how that can look. An administrative period can be up to 90 days. Here's an example from the regs. If the measurement period is October 15, year 1 to October 14, year 2, the administrative period would be October 15, year 2 to December 31, year 2, and the stability period would be January 1, year 3 through December 31, year 3. It's kind of awkward, isn't it? That's straight out of the regs. For most of my clients, they're saying the measurement period is January 1, year 1 to December 31, year 1, and the stability period is, the following type of calendar situation. So you don't have to have that administrative period. Most of my clients see that's just kind of a nuisance. Identifying full-time employees. Okay, we've got more relief. The relief says it allows an employer to adopt a shorter measurement period, such as 6 months, but keep the longer stability period, like 12 months. The measurement period must be, say, 6 months long, begin no later than 7/1/14, end no earlier than 90 days before the first day of the 2015 plan year. Basically the same rule we had under the proposed regs, except the dates have changed. They've been moved back 1 year. And here's an example that you can look at later relating to how this transition relief will actually work. We have a new employee measurement period under the final regs. Notice how many times I've said new? And again, some of your articles are written saying there really aren't that many changes. I think that's quite a few. All right? We have a new variable hour, part-time, and seasonal employee measurement period. The first measurement period is the first year of service. Must begin any date between the start date and the first day of the next calendar month. And the second measurement period is the employer's regular measurement period for ongoing employees. Basically what this means is if an employee starts April 15th of 2014, the measurement period for the first measurement period will be April 15, 2014 to April 14, 2015. The second measurement period would be January 1, 2015 to December 31, 2015. So you're reverting to the employer's standard measurement period. What that means is the two measurement periods overlap. From January 1 to April 14, you've got both the initial and the second measurement periods going on at the same time. Not really new. It's just, again, the dates were changed to fit with the other delays. But we had that same basic rule under the proposed regs. We have a new administrative period, and that is the administrative period, measurement period may not extend beyond the last day of the first calendar month beginning on or after their 1-year anniversary. So the administrative period may not go more than 13 months total. Okay? The administrative and measurement together. The new part of this rule is any period before the initial measurement period begins counts against the length of the administrative period. So if they're hired on the 15th and the measurement doesn't begin until the first of the month following, then the administrative period has to be reduced by 15 days. Because there was a 15-day gap between employment and the first measurement period, and that comes off the administrative period. Okay? The stability period, again, has to be at least 6 consecutive calendar months. More? Ready? Why don't you just take a deep breath for a second? Okay? The stability period, new employee stability period. At least 6 consecutive calendar months and no shorter than the initial measurement period. If the employee averages less than 30 hours a week, the stability period cannot be longer than the initial measurement period plus 1 month. Remember this, the employee status is determined again during the first measurement period. Okay. That was another really complex set of rules. Let's look at some special rules. There are special rules about rehired employees, but you do remember from the first part, what about rehired employees? Don't do it. Never ever rehire an employee. They make your life miserable in more ways than one. Not limited to these rules. There are special rules on breaks in service. 26-week breaks for educational employers, 13 weeks for others. These rules basically relate to most K through 12 employees work 9 months of the year. Summer school, my daughter and son-in-law are both teachers up in Iowa, and they say, the school districts are really cutting back on summer hours. New rules on unpaid leaves. New rules, special rules on changes in employment status from part-time to full-time. Educational employees have credit hours for breaks. We've got the breaks particularly about summer breaks. One of the other things we look at the college level is what about sabbaticals? And how do sabbaticals fit into all of this? Okay? Those are the measurement rules. I know. They really are not any fun, but you know what? You're still going to have to do it. And you're going to have to figure out which of these rules apply to you. I had to go through them really fast. I know we've got a lot of folks from Branson in here, and you're really going to be affected by the seasonal rules, and so I tried to pound on that one a little bit. I know we got school districts and such in here, but the real answer is you're going to have to take these rules and see how they apply to your organization. And do you have any special rules for your organization? We've got some charts that when we work with a client on this, we have them fill out information in this chart format that will allow us to get to kind of the bulk of the issue quicker than if we're just sitting there asking questions. All right, what are the penalties? As before, there are two types of penalties. The no coverage penalty, meaning failure to offer coverage to all full-time employees, and the unaffordable coverage, the coverage is offered but it's not affordable and doesn't provide minimum value. In order to trigger the penalty, at least one full-time employee must qualify for a tax credit or a subsidy. So if you have unaffordable coverage and any one employee goes and buys coverage on the exchange and gets a tax credit or subsidy, you now have that penalty that can attach to you. The subsidy, here are the rules, not going to go into them. All we care about is, did they get a subsidy? And so, but if you want to know when the subsidies kick in, there they are. The no coverage penalty works like this. The employer does not offer coverage to all full-time employees and their dependent children. The penalty is $2,000 per full-time employee minus 30. That's what I told you the last time I was with you. For this next year only, instead of 30, it's 80. So you don't have to pay, you get a free 80 employees instead of 30, okay? It's adding 50 to the number. Why? Because it ties into the difference between a small employer and a mid-sized employer, okay? That's only for next year. In 2016, it goes back to 30. At least one employee must receive a premium tax credit or subsidy. The employer will receive a notice of that and will then perhaps have to pay the penalty. It's important to document that you offered the coverage and the employee waived the coverage to try to get out of these penalties. The 95% rule says the $2,000 penalty will apply unless coverage is offered to at least 95% of all employees. If fewer than 95% are offered coverage, must pay the penalty for all minus the 30, or next year 80. You must also offer coverage to dependents to qualify for the relief. Spouse is not a dependent. Now that may surprise some of you, but that's not really for pay or play purposes, that's just for marriage purposes. Spouse, you don't have to offer coverage to the spouse, you have to offer coverage to the children dependents. Now, we can't keep any rule. So for next year, the relief is, instead of 95%, it's 70%. Again, it's the government saying we're trying to work with you here. Why'd they pick 70? Don't really know, but here's my theory. Because that's what most state rules require. That an employer offers a plan and covers at least 70% of the employees. That's the rule in many states. That's the rule in the NAIC model. Pay or play penalties. If coverage is offered to all, next question is it affordable and does it provide, oh, one more thing on the 5, the 95%. Don't use this rule to say, cool, we can carve out 5% and not offer coverage to them. That's not the best use of this rule. Use that 5% for your oops. We didn't cover this person and we should have, or these people, but they're less than 5%. If you carve out 5%, then you don't have any oops. You don't have any oops factor. All right. If coverage is offered to all full-time employees, meaning what percent? What percent? Next year? Year after? Great. If you meet those tests, then the next question is the coverage affordable, and does it provide minimum value? Let's see. If the coverage is not affordable or does not provide minimum value, then the penalty is $3,000 for each employee who's affected by that non-affordability and non-minimum value, receives a premium tax credit. And the key here is neither the 30 nor 80 employee rules apply. No credit for the first 30 or the first 80. The 9.5 affordability test relates to the employee's share of the premium for self-only coverage. It cannot exceed 9.5% of the employee's income. If the employee, and I have an example, employees earning $30,000 a year, which is $2,500 a month, the employee's share of the premium cannot exceed $237.50. Otherwise, it doesn't meet the affordability test. There are some safe harbors, and we have several of them. First off, 9.5% of W-2, we already talked about it. The rate of pay for hourly employees does not exceed 9.5% of 130, multiplied by a lower of the rate of pay as of the first day of the plan year, the lowest hourly rate of pay during the calendar month. What this really relates to is you've got to play fair. Don't reduce the employee's pay to meet the affordability test, okay? Number 3, non-hourly employees, the 9.5 applies as of the first day of the plan year. We also have the stats here on what the federal poverty level is. Those are new numbers for this upcoming year. Minimum value test is, and this is all the same, so I'm going through it quick. Plan must pay for at least 60% of covered benefits. The employee cannot be responsible for more than 40%, which is what type of metal plan? Bronze, exactly. Wellness incentives are not considered except for tobacco cessation, and that is absolutely allowed to kick in, and you can assume 100% success rate. There are 3 methods for determining this test, and I won't go into all those methods because we did that last year. Common control issues. This is a big deal for a lot of employers. When determining large employer status, all employees of related employers are counted together when determining whether or not it's a large employer. When looking at the penalty part of the calculation, you look at each employer separately. For the no coverage penalty, you take that 30, or for next year, 80, and you prorate it among the related groups. So let's say we have a parent company with 3 subsidiaries. So we have a total of 4 companies, and they all have the same number of employees. Then each would get a credit of 20, because you take the 80 and you divide it by the 4. You prorate it, okay? And so they're counted together for the large employer test, but they're prorated for the penalty analysis. What are your options with respect to the penalty? Run. If the employer doesn't have coverage, offer coverage or not offer coverage and pay the penalty. Factor in the 30 employee credit. We want to point out that the penalty is a non-deductible excise tax, so the penalty is not deductible. And you want to look at what's the tipping point? What's the tipping point between the no coverage penalty and the unaffordable coverage penalty? And that's an analysis you can go through, and we've got some examples we can show you if you're interested. You could cover folks, but some might not be eligible, either based upon a classification. There's a lot of issues out there about can we class this group out, can we class that group out. Again, the non-discrimination rules come into play. You might have coverage, but it's not affordable. This is happening a lot. And you have a couple of options here. And let me just say one thing on this. The penalties have been delayed, but I encourage you to be running the tests now anyway. Not running the tests and voluntarily paying a penalty a year early, but run the tests to see where you are. Are you potentially going to have an issue a year from now? And so if you are, maybe you can use some of these remedial measures to get yourself away from the penalty. Maybe you need to make your coverage more affordable. So if it's not affordable and you want to make it more affordable, you can increase the employer portion of the contribution. And you look at what's the tipping point between paying the penalty and increasing the contribution, which is a better deal. You might reduce the benefits but stay within the 60% bronze level. You could reduce the employee share of the premium but increase the employer share, or you could also reduce wages to pay for the higher employer share. You can factor in the likelihood that some employees will go to the exchange. Your premiums may suck. Employers say, man, those are high. Dang law firm. I'm going to go to the exchange instead. Factor employees who will not participate in exchange. Or you can use reverse discrimination. And we're actually seeing this more, where the more you make, the more you contribute to the coverage. Okay? The more you make, the higher the dollar amount or the higher the percentage that the employee's share of the coverage is. There's also a technique going on out there that says the employee contribution to the coverage is 9.5% of the W-2 wages, which is kind of neat just in its simplicity. What if you fail the 60% minimum value bet test? Then you can increase the benefits and the premium. You can increase the benefits employee premium, keep the full-time employee level below 50, keep the number of full-time employees as limited as possible. The final item is restructure your part-time employee hours. Be careful. We've seen lots of discussion. Well, what we're going to do is take our full-time employees and go to them and say, well, for the past 15 years, you've been working 40 hours a week, but starting next year, you're only going to work 28. And that's going on. We've heard about it. Now, is that specifically written against in these rules? No. It's kind of in some of the changes in our February rules, that second part of, we're going to give you relief, but you better play fair. But that could also lead to ERISA litigation. And it's ERISA litigation under a section that says it could violate an interference with an employee's rights, being the right to have health insurance. You lowered my hours so that you don't have to pay for my coverage, and that could lead to one of the special type of litigation. Okay? How skimpy can coverage be? Last year, I was interviewed in the Wall Street Journal about skinny plans. Skinny plans are plans that are kind of designed to say, well, we offered a plan, but they turned it down. Just happened to be a real skinny plan. And the question is that in this formula, well, backing up, the rules say you have to offer a minimum value plan and an affordable plan. Those who've crafted skinny plans say, does that mean you have to offer a plan that is minimum value and affordable? Or does that mean you have to offer a minimum value plan and an affordable plan? You with me? In other words, can one plan be minimum value and the other plan be affordable? So the idea would be that you offer two plans, a minimum value and an affordable. The minimum value is going to be the traditional plan we've always had. That's a major medical plan. The affordable plan would be something like a mini-med, or a skinny plan, or a bare bones plan. And there's a lot of this in the market out there, and it's been out there. When I was interviewed, they said, "Do you think this works?" And a year ago, I said, "It might, but you better have a plan B." Because I personally think and means and. This plan has to be minimum value and affordable. I can see where you can concoct the argument. That's going on out there. Beware. Particularly with the new regs in place, I think skinny plans are very dangerous. Both from the standpoint of, do they meet the affordability test, and how else would they potentially be in trouble? What other rule am I thinking of? Pull it out of you. What's the other rule I'm thinking of that I said is going to overcome a lot of this? I hear it, non-discrimination. We offer both plans, but our HCEs all take the minimum value, and our NHCEs all take the affordable. Is that now discriminatory? Because our HCEs all have a good plan, and our NHCEs all have the POS plan. Okay? So, again, those non-discrimination rules are absolutely going to be key. One more thing about these rules, and these are the reporting requirements. There are 2 new reports that are going to be due in 2016. In EBIA, we're doing an hour-and-a-half webinar on these, but I'm doing one slide today. 6055 and 6056 reporting. 6055 will come from the provider, the carrier, and 6056 will come from the applicable large employer. And these verify the months that covered individuals have MECs, minimum essential coverage, and then the 6056 applies to what coverage has been provided to full-time employees. Okay? That's the end of pay, play, or delay. All right, take that deep breath now. We got a lot more, or not a lot more, I've got 2 other topics I want to cover. Before I do so, let's do something just for a little bit of fun before we get into the next set of rules. Several of you have reminded me today that the last time I was here, I had no voice. And I was fighting a major, major head cold. And there was something I didn't do. I did not bring my guitar and sing because I could barely speak, let alone sing. I am going to remedy that right now. Last year, I actually wrote a song that I wanted to do for you. I'm going to do that now. This may be a little bit clumsy because I actually rewrote this song last night in the hotel room to update it a bit. So it is really a bunch of cat scratches right now, but I'm going to try to go through this. If you remember, 2 times ago when I was here, I did a David Bowie song called Changes, and I called it Exchanges. And I said, and at one of my sessions, I got up and said, I'm going to do a David Bowie song. And somebody came up after and said, boy, that's not the Bowie song I thought you were going to do. I thought you were going to do this other one. And I ooh, that one would be good too. So I'm going to call this one 2014 Marketplace Oddity. HHS to President. HHS to President. It's 2013 and time to roll out HHS to president. Commencing countdown to October 1. Check the portal and may many folks enroll. This is President to HHS. I really hope it's ready, 'cause the papers want to know who is in charge. And the website sure had better not crash. This is HHS to President. We got some real bad news. There were a lot more folks than we expected. And the damn IT did not get it right. For here are we sitting in a fishbowl, right in Congress's eye. Pay or poise delayed, and the Republicans keep voting to repeal. Now we've written thousands of pages of regs and allowed many delays. And I hope that OPM knows which way to go. Tell the public to trust us, oh no. Carriers to HHS, the time has come. There's something wrong, can you hear us, HHS? Can you hear us, HHS? Where are you, HHS? All right. I have a voice this year. It's also time I need to be writing some new ones. I'm starting my teaching season, so there'll be another new one for you next time we're together. All right. Let's talk about sex. There's been a lot about benefits and sex here lately. First off, we had the Hobby Lobby case just argued. And the Hobby Lobby case relates to the required coverage of first dollar basis for contraceptives. There is an exemption in the statute for religious employers. And the government says a religious employer is a church. Hobby Lobby says we're an employer that's religious. We're not a religious employer, but we're an employer that's religious, and to pay for contraceptives violates what we believe in terms of our religious beliefs. If you heard the arguments or read a thorough summary of the arguments, the Supreme Court's in a very tough spot. The two sides of the case are, Hobby Lobby is saying this violates us and we have freedom of religion rights. A number on the court in their questioning seemed to go along with that, but another number of the court said, but where does this stop? In other words, some religions don't believe in vaccines. Some religions think it's inappropriate to do a blood transfusion. Some religions think it's inappropriate to do medical care, like Christian Scientists. So where does this stop? And that's something I think both sides of the court are going to be looking at. I have read from those in the room who heard all the arguments. I've heard folks that have come away from the case saying they're absolutely going to rule this way or they're absolutely going to rule the other way. We really don't know what's going to happen out of that, but that case will be interesting. There are a lot of similar cases brewing at the lower court levels. Number two is DOMA. which is the Defense of Marriage Act, the federal act. This case was the Windsor case. There are 3 parts of DOMA, and the Supreme Court did not do us any favors. There is Section 1 of DOMA, which is the title, Section 2, which is the full faith and credit clause, which says states do not need to recognize same-sex marriage as valid in another state. So Missouri doesn't have to recognize them. Our number 1 scenario is the closest state is Iowa. So Missouri doesn't have to recognize a marriage conducted in Iowa. Section 3 is the federal definition of spouse and marriage. The Windsor case was actually not about benefits. It was about estate taxes. And it was a claim for a refund of estate taxes that wouldn't have been paid if the state recognized the marriage between Edith Windsor and her partner. They were married in Canada and they lived in New York. So it really wasn't a benefit case, but most of the implications of it do relate to benefits. The Supreme Court, in a 5-4 decision, ruled that Section 3 of DOMA was unconstitutional, but did not address Section 2. So if you look at what's left of DOMA, the federal definition of spouse, which was a person of the opposite sex, was struck out, but Section 2 remained, which says states do not need to recognize same-sex marriage as valid in another state. And we all kind of went and looked at that and said, thanks a lot. He didn't tell us anything. I mean, what are we supposed to do with Section 2? And they gave us no guidance with Section 2. The Supreme Court didn't. The agencies are now giving us guidance. In the past few months, the IRS came out with guidance that has a state of celebration rule. And it says definition of a spouse for federal tax purpose includes an individual married to a person of the same sex if the couple is lawfully married under the state law where it was performed. This only applies to marriage. Doesn't apply to domestic partnerships or civil unions or other types of relationship. The IRS has also taken this rule and applied it specifically to cafeteria plan treatment, saying the same-sex spouses can have the premiums paid on a pre-tax basis if the plan allows that for opposite-sex spouses. The FSA, same thing, that you can get that favorable tax benefits. And it also said that same-sex couples can amend their prior tax returns, just like Windsor's partner wanted to do. That's the IRS guidance. The DOL came out with guidance in Technical Release 2013-04, which was consistent with the IRS guidance. One thing that's kind of interesting that's going on right now is a lot of the agencies are doing regs. HHS is doing the most regs. We also have IRS and DOL, OPM, other parts of government are doing regs. HHS has by far the vast majority, and HHS is actually borrowing reg writers from the IRS and the DOL because they don't have enough reg writers. So when I say that the DOL guidance is consistent with the IRS guidance, it may be because the same person wrote it and was being borrowed, or one group of individuals was put down to, or put down, it sounds like a pet. They were brought together to come up with consistent guidance between the agencies. The DOL also came out with guidance, and this really isn't benefits, but it'll be another part of HR, relating to wage and hour issues with respect to same-sex spouses. And then, most importantly for us in benefits, this just came down a couple of weeks ago. HHS came out, and let me precurse this just a little bit by saying, in the state of Missouri, there are a number of rules which we call offer of coverage rules. And they'll say, for example, that a carrier has to offer an employer coverage for blood transfusion, I don't know, anything. Doesn't mean the employer has to accept it, it just means the carrier has to offer that to the employer. The employer doesn't necessarily have to put that in their plan document. Well, HHS came out with an offer of coverage rule that says if a carrier offers coverage for opposite sex couples, spouses, it also has to offer coverage for same-sex spouses. That doesn't mean that the employer has to offer that coverage, just that the carrier has to make that as an option that the employer can accept. So it doesn't, and there's been a lot of articles on that, and it's just, a lot of the articles are wrong. Just the carrier has to offer the employer that option, the employer doesn't have to take that option. I just have here a status of state laws. I'm not going to go over that, but if you're kind of curious what the status is in various states, that's a little bit on that. Latest issues and risks. Plan sponsors may still limit coverage to opposite sex spouses. However, there's certainly going to be a risk of litigation. You know, one thing, and I keep using the tipping point analogy, this is one place, certainly with this administration, that it appears the tipping point has been reached. So there's a likelihood of litigation, mainly under Title VII. There should be some gender discrimination. There are a number of pending cases right now, such as review of constitutionality of state laws, review of same-sex couples regarding recognition of their marriage, and then there's a website which my associate Belinda Aguilar, who's really tracking this, called the Freedom to Marry website, which says there are currently 60 DOMA lawsuits in the federal courts going on right now. Okay? A little bit about DOMA and contraceptives. Let me finish up, and we're pretty close to on time here. Let me finish up with HIPAA. Now, this talk was supposed to be about health care reform. HIPAA has nothing to do with health care reform, but it's extremely scary. Extremely scary. When HIPAA first came out, there was this rush to comply. A lot of carriers got really active with it. Large employers worked on it, got it done. TPAs, brokers, all were scampering to become HIPAA compliant. And this happened for a couple of years. By the way, this was in '97. And then you know what? Nothing happened. Because the HIPAA statute didn't give the government money to hire auditors. So there were no audits. And people kind of figured out, if they're not going to audit, then I'm not going to do anything. Then high-tech came out, and same thing happened. Under high-tech, a lot more groups are brought within having a primary responsibility to comply with HIPAA. And so a lot of groups got real active, and I was doing more seminars on it. And the same thing happened. There weren't any auditors, and so nobody did anything. And then about 2 years ago, they funded the hiring of auditors. And between auditors hired directly by the government and auditors under third-party contracts with other vendors, such as KPMG, HHS has hired KPMG to do HIPAA audits. Now there are well over 1,000 HIPAA auditors out there. And they are issuing very large penalties. Let me just talk a little bit about what's going on. There are new individual rights. There are new rules on sale and marketing and PHI, and there's a lot of new rules on breach notification. there are a lot of breaches going on. And you have to take a look at when there's been a breach and see, is that breach reportable? And we've been doing that with a lot of clients. But let's talk about what's going on in some of these audits. I'm just going to talk about 3. The first one relates to is Blue Cross Blue Shield of Tennessee. And what happened was on a Friday afternoon, they had left their server behind in a prior office building and moved to a new office building, and were going to bring the servers over. They had a lot of security around those servers, such as a biometric screener to get in and even get near the servers. But on a Friday afternoon, the server sent a message back to IT at the new offices saying that there is a server problem, a non-responsive server. And Blue Cross didn't check into it until Monday. They didn't look into it on Friday afternoon because we all know how hard Blue Cross folks party on Fridays. HHS looked at that and said waiting 3 days to check the server resulted in a $1.5 million penalty. Okay? One of the key facts is there's no evidence that any PHI was actually leaked. Only that they didn't respond quickly enough. Okay? The second one was up in Alaska, and it was Alaska State Agency, and an employee had his car stolen. And in the car, he had a USB drive with some files he had taken home to work on the weekend. The stolen car had in it the stolen USB drive. Now, that thing might have fallen in between the cushions of the seat. Again, no evidence that any PHI was actually leaked or breached. But the penalty was $1.7 million. Okay? The third one. Do you know a copier has a hard drive in it? And that hard drive retains an image of every copy ever made on that copier? AvMed out of New York did not know that. And they had a copier on a lease. They turned it in and got a new copier on a new lease. The leasing company then sold the used copier to another employer. And AvMed had really epically bad luck. You know who the copier was sold to? CBS News. AvMed did not know that there's a hard drive on the copier. Whenever you turn in a copier, you need to have the hard drive removed and destroyed, just like any other hard drive in a computer. The penalty was $1.2 million. That was the easy part. The other part of the penalty was, HHS says, you need to go find every other copier you've ever turned back in on lease or sold as used and destroy them. Where the heck might they be? It's not like they're registered like cars, you know? So they had to go find all the previous ones. The point is that there are huge penalties for very minor violations. If you look at those 3, there's no evidence that anyone's PHI was actually leaked. Maybe in the third, because these are reporters, man. They're going to snoop.
I hate to stop you there, but I'd like to take...
I got one more slide.
Go ahead.
This is the closing thoughts. Big year ahead. Stay on top of the developments through Connell, through us. Focus on the ACA. Don't let the penalties slow you down. It's really important you stay on top of this. What we also want to say, get on top of HIPAA. There is a whole new paranoia in the IT world and in the security world about what's going on with HIPAA. More than anything, we're here to help. We're here to help guide you through this. As we go into the questions, some of the questions are probably going to be a little challenging to answer, but we'll give it a try. Try not to be too specific. Some of us will be hanging around to answer your specific questions. Final thing I'll say before I hit the questions is I really enjoy being with you all, enjoy being down here, and I look forward to seeing you all again. All yours.
As Andy said, it's confusing, it's complicated. Every employer's circumstances are a little bit different. However, we would like to give you the opportunity to ask questions that may be able to help you. So, are there any? I know a lot of people wrote questions down. Is there anyone brave enough to have me?
Got one over here.
We got one over here. So, just to repeat the question, that was
good.
on the waiting period. Should the first of the month following 90 days be in effect now, or is it 2015? Is that what your question is?
And the answer is yes and no. The central piece of that is yes, it's in effect now. Some of the testing concepts of that are not in effect yet in terms of some of the other 90-day and 4-month rules are part of that. But that's something that you should be working toward right now. Okay? Yeah, right up here. Okay. If the employer, and I'll just rephrase that one, if the employer says, we're going to pay, not play, what's the process? And that's part of the reporting function, and not all the forms are out yet. We do have the 6055 and 6066, but I think your basic question is, do you have to go ahead and pay it, or do you hide under your desk and hope they don't find you? It will be a process where you will have to pay it. The parts of the reporting process are pretty complex. When any employee goes to the exchange, one of the difficulties and one of the things that help shut down the exchange in those first few days is how complex the information is that they had to enter, and that's what upset a lot of employees. But to make this whole process work, the exchange needed to know who is your employer. So the exchange is going to know from those questions that you're not providing coverage and it's your employee who came and got the subsidy. So yes, it's not like some of this HIPAA stuff. We've been doing this for years and haven't got caught yet. It'll be a first-year compliance issue.
If you offer affordable care, the affordability factor and the minimum value, and you offer it to the employees, and they decide to go out to the exchange anyway, are you going to have to pay if you've met those other two requirements?
So you're looking at the unaffordability test, or the affordability test.
The affordability and the minimum value.
The minimum value.
Are you free if you cross those two? You don't have to worry about it.
If you meet the various rules that we go through, that we went through today, and the various percentage rules and all that, even if they don't accept and even if you go to exchange, you can still be okay. Okay?
Can you elaborate on the children part? What
Uh-huh.
you had in
Yeah, and I didn't talk about that as much today. I talked about that a lot more last year. You basically look at the children the same as the employee. Now, the difference is, and I talked about this more last year, the children's coverage doesn't have to be affordable. You have to offer the coverage to the children, but it doesn't have to be affordable. One of the techniques you can look at is to meet the affordability test. Some employers we're planning to decrease the employee share of the premium on the employee rate and correspondingly increase the premium on the dependent rate. So it helps meet the affordability criteria, which applies only to the employee portion and not the dependent portion.
Second question.
And again, spouse is not a dependent.
Okay, then I have another question. I totally missed this. I must not have had enough coffee yet. And this was way back when you were before the break. you mentioned something about making sure you put a financial statement on your website.
Transparency. That applies to carriers, not to you. HR folks don't have to put their financial statement on the website. That applies to carriers. It's part of that. It kind of ties in with MLR, so that, employees can go in and look and see, is the big bad insurance company ripping me off? When MLRs came into being, and when we were following the whole beginning of the ACA analysis and what was being talked about in Congress, and one of my carrier clients I went to meet with, and because of HIPAA reasons, and I'd trained them well, they met me at the reception desk. They walked me up to as the general counsel. The carrier came and got me and went up, and we had 4 different meetings throughout the day. And it was that time when all the hearings were going on, and they were just beating carriers up all over the place. So I had my 4 meetings, and these are folks I've worked with for years and years and years. And as they were supposed to under HIPAA, they were walking me out. And as we were saying bye, I shook the general counsel's hand, and I said, "Good to be with you, and I really enjoyed being here in the halls of avarice and greed." So, the question was, are employees responsible for 100% of the cost of employee coverage? And the standard plan design, the answer to that is yes. We have a number of employers who contribute to that. And, we have some scenarios. One thing in my own firm, we're a benefits firm. We think we should have the best benefits of anybody. And so we have a period where if you've worked with my law firm for a certain period of time, after that period of time, we pay 100% of the family rate. So, in that case, that's probably not going to change. But in most scenarios, we do see that the employee pays the full dependent premium. Again, one of the tools that we're seeing to meet the affordability argument or the affordability analysis is by maybe reallocation of the employee contribution away from the employee rate, which is the only thing the test looks at, to the dependent rate and raising the dependent rate. Follow-up. Yeah, you look at it, and I did one little analysis on that slide. I think I had an employee making was $30,000. You can look at it from 2 standpoints. If they're making this, what's the maximum premium I can charge? Or you can also look at it from the side you're talking about is, what is that employee premium, and then back it out the other direction. And it's important to look at both. Hey, nice thing about raising the minimum wage is it'd make it more affordable, right?
Again, we got one more question.
I'm sorry, say that again now. Tax credit as opposed to deductibility? The tax benefits, insurance premiums are typically deductible, but rarely do you see a tax credit, which is a different thing under the Internal Revenue Code. Deductible means it comes out of adjusted gross income. The credit is a dollar-to-dollar offset against tax.
Again, Andy, thank you for making the trip down. We appreciate it very much and keeping us up to speed.